Bhulabhai Desai address to law students at Pune in 1937. Bhulabhai J. Desai is regarded among the foremost lawyers in modern India. He practiced law at Bombay High Court and was the defense lawyer of Shahnawaz Khan, Gurbaksh Singh Dhillon, and Prem Sehgal in the famous INA trial by court martial in the Red Fort in 1946. He was a member of the Central Legislative Assembly from Gujarat in the first elections of 1937. He was also member of the Congress Working Committee and was a very close associate of Mahatma Gandhi and Vallabhbhai Patel. His unfortunate death in 1946 was a big blow to all Indians who were expecting a bigger role for him in free India. Reading out his address to the law students in 1937, this was published in a collection of his speeches from 1934 to 1938 titled Speeches of Bhulabhai J. Desai, published by J. A. Natesan and Company, Madras, and printed in Hindustan Times Press, New Delhi. Address to law students. I addressed the law students of Pune many years ago when Mr. Gharpure first started this great venture. I am very glad indeed to meet you again after many years. Probably I am meeting the next generation. The generation to whom I talked when I was here last time are now probably lawyers of consequence in this city, and the generation that is now coming forward has a future in their keeping insofar as citizenship or citizen life is concerned. I was wondering as to what might be the proper thing to tell you, whether I should enter upon somewhat serious, obtruse subject of jurisprudence, or whether I should take up one of the actual subjects with which you should be concerned for your examination, or whether I should talk to you to a certain extent on what ought to be your outlook on life, both professional and personal. The last appears to be, to me, much more appropriate than attempting the role of Mr. Gharpure and his colleagues. It may be that from the point of view of examination, I may not give you anything worthwhile at all. But it is one thing to pass examination and it is a different thing to apply knowledge which we have acquired for the purpose for which it is intended. Many years ago, there used to be a very healthy custom in Bombay where annually the Chief Justice and rest of the judges, many lawyers, and all the young men and women of law college used to get together to celebrate a function to which we gave no name, but where one of the members of the profession was expected to deliver an address. It is not much to my credit that the last address which was delivered of that series was delivered by myself. Since then, I do not know what has happened to the succession of lawyers. That welcome custom has been discontinued. I propose to devote part of this time that I shall be with you for giving you a definition as I can. It is more a description than a definition. That is, definition of law, of which I understand to be law. And I also propose to tell you, in the rest of the time, your obligation to society, both as student of law and afterwards as practitioners of law. When I was in your place, the book that used to be taught was Austin's Jurisprudence and also Holland. Law was there defined as the command of a sovereign with a sanction behind it and an injunction to the subject to do or to omit doing a particular act to which was annexed a punishment of some kind or other by reason of that sanction that the sovereign possessed. To the extent to which the definition went as a rule of conduct for life, I have no quarrel. For indeed, no society can exist as a social institution without recognizing the rights, without respecting the rights either to the person or to the property of every individual that composes that society. Therefore, it is perfectly true that it becomes the primary duty of every sovereign to prescribe the rules of conduct which are less than ethical. This fear we must, for the purpose of this discussion, exclude. The social well being of society is the main purpose of the injunction to do or not to do any particular act in the larger interests of the body to which you belong. This is an important qualification because if it was merely an injunction for the benefit of society, as it happens today in this country, a mere voluntary action depending entirely on your consciousness would not be law, though to me it is the higher law. That would not be law in the sense in which you are being taught the law. The important condition of the existence of the law that you are being taught is that you may call the coercive process of society by which, if you depart from that law, you are compelled to conform to it or suffer the consequences. The essential distinction between ethical law or the law of consciousness and social law of the state is that, insofar as the latter law is concerned, it has behind it the strength of the state, the power of the state, or as it is sometimes called, the arm of the law with a view to enforce obedience. After 4 or 5 years ago, I commended to the attention of law students here 3 or 4 lectures were delivered by Lord Macmillan on the essence of what I have called law from the point of view of the state, because it largely depends upon what you call sovereign. That makes the law not merely its utility and not even its sanctity, and you may easily understand it if you begin with the conception that I gave you. Let us take a practical illustration. We will assume that a sovereign is an autocrat and that his will is law. The definition would undoubtedly be satisfactory because he has behind him the power of the state, and through its medium he is in a position to enforce obedience to any injunction either to do or not to do which he deems beneficial to the state of which he is the head. You then realize its limitations at once, for you may have what you may call a sovereign who is very beneficent, intending to do good to you, and having all the power in himself to give the injunction as to your line of conduct, but he may easily be succeeded by another sovereign who may not take the same view of his obligation to you, or he may easily conceive that to be good for you, which he thinks is good for you, but which may not be really good for you. In other words, the value of the law, notwithstanding the sanction behind it, depends upon the source of law, and ultimately it depends on who constitutes the sovereign that makes the law. Sovereign will. In most of the modern states, the sovereign will is expressed in one form or another by those who are representatives of the people at large, and to the extent to which the sovereign will is expressed by the representatives of the people who get nearer and nearer to a true conception of law which every member of society, even without coercion, would consider his obligation to follow and obey. To the extent to which our representatives make the law for you, it is obvious that there are 2 conditions which should be satisfied. The first is that they naturally express what is good for you, and secondly, inasmuch as they are representatives, you have made the law irrespective of the coercive process of the state. It becomes your duty, your obligation to obey the rule made by your representatives. In other words, the source of law is the real ultimate test of the value of law from the point of view of society to which you belong. The nearer that law is made by the society at large through its own representatives, the nearer it reaches both in value and in sanctity so far as obligation is concerned. This raises a very grave issue, which this is not the time nor the place to argue or discuss about, but you will easily see from what source and from this analysis of the law that where more and more power and authority are concentrated either in an individual or in a group, greater and greater it is removed so far as sanctity of obligation is concerned from the point of view of a citizen. Take, for instance, the last civil resistance movement. I want you to understand and examine it purely as students of law, for that is my only purpose in trying to explain this aspect to you. During the last civil resistance movement, I was often asked questions by many lawyers and by many administrators of the law, and indeed you will find the platitudes reach not merely the lower courts but the highest courts of judicial pronouncements, namely the Privy Council, which decides appeals from India. Of course, for the moment, being administrators of the law, they do not bother as to the source of the law and only raise the question whether you have obeyed the law. In one of the judgments which arose out of civil resistance movement, that is to say, disobedience of the law, deliberate or voluntary, they said that those who live by the law cannot break the law. A phrase which caught the minds of many lawyers who did not give a thought to it at all. They seemed to imagine that it contained such a profound wisdom that there was nothing more to say about it by way of analysis. They forgot that the Privy Council, intending to maintain the present source of law, namely the British power, had to say that whatever they thought fit to maintain the society in its existence should be law, and therefore those who practice the law should conform with the rule that if they do not obey their law, they were not fit to practice the profession at all. I would like you to follow the analysis a little further, purely as students of law, so that you may see where the catch lies. It is true, it is a good phrase that those who live by the law should obey the law, but the catch lies in the fact as to who made the law and for what purpose. If I conceded the right, say, to one individual to make all the law for the conduct of every citizen of the society, so long as he is human, he will declare everything to be the law which maintains the autocratic concentrated power and authority with that possessor. And if it becomes duty in that set of circumstances to obey the law, there is no means of removing the concentrated authority from the hands of one man, and hence you will see that in course of time, under international law, when a successful revolution establishes a new government, that government is called government established by law. In other words, there is an immense amount of limitation, examining it purely from the point of view of jurisprudence, over the duty of a citizen to obey what is called law to the extent to which it is made by the citizens for the benefit of the citizens, and to the extent to which the obedience to law leads to the progress of society and maintenance of its integrity. But if you carried it to the extent to which most of my friends who argue with me during the last 10 years have carried, you will get into a vicious circle and get an entirely wrong conception of law. If you must obey what is called law, made by one to sustain his power over it, will it be impossible to display that sovereign so that you must reach the stage where, without breaking the law of that particular sovereign, you cannot establish a new sovereign in any form or shape that you desire? You have only to look at the English history for the ultimate disregard, ultimate abandonment of the divine right to rule. It is common to find sovereigns claiming divine right to rule in order to maintain authority over their subjects. Here in India, also many sovereigns claimed that divine right. You know that some Rajput princes claimed descendant from the moon and some from the sun. A sovereign, by a psychological process, so numbs the society mind that they accept what he says, believing that it is drawn from another power and thereby imposes his authority. When society wakes up, the authority that is claimed by the British Parliament is for the good government of this country. Its origin is conquest by them. It is called governments established by law. Therefore, while you are practicing the law purely in a court of law, that is to say, the courts as they now exist, your standard of law is merely to take what is there prescribed, put a meaning upon it, and test by it whether a particular individual is right or wrong, but you will be quite wrong in supposing that it is the final test of law. Law is often put to the final test as soon as society wakes up to its own right. Curiously enough, either in Roman history or in European history, there are exactly two opposite conceptions of law. There is the divine right of kings, where the individual with power behind him wants to impose the law upon his subjects in order to maintain authority, and there is the other, vox populi, vox Dei. Now, which of the two is right? Is it the divine right, or is it the voice of the people is the voice of God? That is vox populi, vox Dei. In other words, where is the divinity? Therefore, as soon as society wakes up to the idea that they are not merely autonomous in the hands of one superior authority, but that they are makers of their fortune or unmakers of their fortune, as we have hitherto been, they become makers of law. In other words, revolt against law by a sovereign authority who does not express the will of the people becomes then a law unto yourself. We are often deceived as to the true conception of the law itself. I am here to point out to you that, in its essence, if the sovereignty resides in the people at large, the same definition will again exist that the sovereign will command either an act or a prohibition with a sanction behind it. If you read carefully the lectures in which I have drawn attention, Lord Macmillan, lays down this more or less, that law notwithstanding, its definition should be a rule of conduct for the citizen with a sanction behind it, and that law will become nearer and nearer the true conception of law as the maker of law gets nearer and nearer to society itself. Therefore, let us all understand that what we have hitherto been deceived into as obedience to the law is a misconception, a delusion, and a fallacy when it becomes to the larger aspect of the citizen's life. From the point of view of society at large, it behoves you to display a little more courage and not be deceived by the kind of analysis that those who live by the law must obey law. In other words, the lawyers must be slaves. We allowed ourselves to be largely hypnotized, believed it to be our duty and function to support what was not really the rule of law. In the name of law, and with our own hands, with our own friends, and without brothers, they broke out our heads. Undoubtedly, every one of us owes allegiance and obedience to law, where that subserves the progress of the people and maintenance of liberty by those for whom and by whom it is made. To obey the law is great social duty, but what they call law, a law which stands for the suppression of the personal freedom, personal duty, for the suppression of the rights of association, for the suppression of one's conviction, that is not law. During the last civil resistance movement, taxes were gathered from the Indian taxpayers. The Indian was employed as a constable. The Indian was employed to cut down wood to make a lathi, and the Indian head was broken. You ought to analyze that to see how much you were wrongly hypnotized. In all human history, power has never come to the people without disobedience of law in some form or other. Therefore, let us not, in an emergency, imagine that there is any sanctity attached to the law made by another for the maintenance of his own authority, and when once you realize that, I think you will understand the threefold distinction. There is the ethical law, which is law of your own conscience, to which no sanction is attached except your own ideas of right and wrong. There is the law made by a society for its own benefit, by its own representatives. The society begins its own sovereign. In other words, the people rule themselves, and there is the law of either a group or an individual, either foreigner or your own countrymen, who have concentrated all authority and imposed the law in order to rule you. Therefore, it is the source of the law which makes it either sweet or a poison, and not the name of the law itself. There is one other aspect to which I wish to call your attention. Every one of us, as a practicing lawyer, is paid a fee, small or large, for protecting either A's property, A's freedom, or A's honor, and we do it with a great deal of enthusiasm, even more than due enthusiasm, almost disproportionate even to the remuneration. But has it ever struck those who live on the society and who are therefore called parasites that they may for payment fight for the freedom of an individual, but they also owe an obligation to the society for which they belong and on which they live? Is it not their obligation to fight for the freedom of the society itself? While as individuals we protect property for payment, protect freedom for payment, protect honor for payment, as a class, have we ever attempted to protect the property of our society? Patriotism is not a dry word. It is an obligation that you owe to society. You attach sanctity to private property, but where comes the sanctity to your own country? The higher function of a lawyer, and it is that alone that gives dignity to the otherwise sorry profession, is that he owes to society, namely the freedom, the honor, and the sanctity of the property of his land possessed by himself. I would appeal to you to make it your future duty. Thank you.